Hi everyone, my name is Jonathan Huza. I'm a real estate lawyer. I practice here in Cornwall. My specialty is, like I said, is real estate. I also focus on mortgages. I do corporate recent estates. I've been practicing real estate now in town for about 15 years. Based in Cornwall, my office is on Pitt Street, just above the Schnitzel's restaurant. For those of you that know where Schnitzel's is, I like the burgers there. That's another point. So I deal with a variety of different clients. I deal with investors, I deal with home builders, I deal with seniors, newcomers to Canada, individuals, francophones, because I'm originally from Quebec, so I can speak French. So I deal with the whole spectrum of different real estate clients. So I'm going to talk to you guys today about 5 different topics that I hope you guys will find useful. The first topic I'm going to touch on is best practices concerning title search dates and closing dates. I'm also going to talk to you guys about deposits, the as-is, where-is clauses that I'm sure you guys see in a lot of your agreements. I'm going to also touch on title insurance and the foreign buyer ban. So let's start off talking about title search and closing dates. First let me touch on what exactly is a title search. So I'm sure you guys are generally familiar with what a title search is. Everyone knows, or all of you would know, that it goes in paragraph 8 of the standard REA APS form. But what exactly is a title search? So a title search is a search that a lawyer does against the property to find out if there's any legal issues with the property that need to be addressed with the seller and the seller's lawyer before the buyer is going to take ownership of the property. So to pull back the curtain a little bit more, to just maybe give you guys a little bit of a peek into what happens at a lawyer's office when it comes to a title search, is our process is probably pretty common for a lot of other lawyers. So when we're acting for a buyer, the way that the process works is that we'll get the APS in our office, then we'll onboard the client, and then we'll actually ask our contractor, who's a title searcher, to search the title of the property, compile all the records on the property. And they submit it back to us, the buyer's lawyer, and then we do our legal analysis of the title search. We look at all the land title records to ascertain if there's any legal issues with the property that have to be addressed. So that would be, we're looking at things like, is there good access to the property? So we're not talking about physical access. We can all physically go to a property. We can see that, oh, there's a driveway, the road's here, everything's fine. There's much more to it than simply just looking with the naked eye. There's also, is there legal access to the property? So that's one of the main things we're looking at. We're also looking at, is there any title issues? Like, is there any liens on title? Is there any mortgages on title? Is there any easements on title? Is there any possible encroachments? Is the structure of the property, like the house, is it on the neighbor's property? Is the fence on the neighbor's property? We won't always know these things, but these are the kinds of things that we're looking at. And then if we see these things, then we will address it with the seller's lawyer. Some of the other things, before I jump to that, is we also check the taxes. We want to make sure there's no outstanding taxes against the property. We're also checking for judgments. If there's judgments against the property, that will bind the property, and your buyer client will have the joy and the privilege of paying the seller's debt, which the buyer obviously has no interest in doing. So once we do the analysis, then we compile what's called a requisition letter. The requisition letter is then sent to the seller's lawyer, and it's sent by the title search date that you put in paragraph 8 of the REA APS. So a couple of things about the date. So I used to tell realtors in the past, put it a week before closing. That's not really ideal. The best time to put a title search date is probably 2 weeks. You want to give enough time to the buyer's lawyer and the seller's lawyer to work out any title issues against the property by giving us enough time, by giving us 2 weeks. The other thing too is I sometimes see when amendments come to our office, the closing date is amended, but the title search date is often not focused on, right? Like a buyer doesn't know what a title search date is. They don't really care. Some agents don't really think about that. It's probably normal because the closing date is really like the key date, but the title search date for the lawyers is absolutely critical. So make sure if you're adjusting your closing date, you're also adjusting your title search date accordingly. The other thing is that if there's going to be, let's say, like conditions, almost all offers have conditions. So sometimes what I see is that the conditional date, I'll call it that, let's say is July 20th. And then I'll see that the title search date is July 23rd. No, big no. That's impossible. It's almost a little frustrating when we get those agreements, because the whole process is like I described before. We get the APS, we contact the title searcher or contractor. It takes them a few days just to get the records back to us in like a few days. If we send them the title search in less than 3 days, they're charging us a premium fee that now our buyer clients are paying. So we don't want to do that. So let's give the title searcher enough time. And once the title searcher does their title search, they bring it back to us. It takes us at least a few days to analyze it, review it, and make sure there's no issues. And once we do that, then we got to put together a letter. We put together a letter, we send it to the seller's lawyer. All that's going to take more than a few days. So I'd say at least 10 days between when the conditions are waived to when your title search date is. Because also, as you guys know, once conditions are waived, it's also going to take time for your office to send it to the lawyer. It doesn't get sent right then and there. Sometimes there's a 3-day delay. And we get it the day after the title search date, and then we're contacting the realtor saying, guys, can you change the title search date because it's already passed, and now you guys are doing more work for fun, which you don't want to do. So that's one thing to keep in mind. Okay, let's talk about the dates for title search dates. Sorry, for closing dates. I think it's just human nature that we all want to put the closing date on the 1st, the 15th, the 30th, or the 31st. I would say 80% of the deals always have those dates. Those are the worst dates, okay? So the reason why they're the worst dates is because your buyer client is getting poor service from his or her lawyer who's doing the deal for them. That's when the lawyers are the busiest, the 1st, 15th, 30th, and the 31st. A great day, like let's say your client wants to close at the end of the month, a great day, July 24th, today. That's why I'm here. I don't have a lot to do today in terms of closings. I have one closing today. On the 31st, I think we have 8 to 10 closings, and on the 1st we have 5. So in 2 days, it's, I don't know, 12 to 15 closings. So, and everyone wants to put it on the 31st. I see all of them coming in the 31st. You know, of course, if the client wants that, you're not going to say, no, my lawyer said no, or the lawyer said no. I get it. It's not like we are the only person to make the decision, but we have a big influence on when the closing date is going to occur. So if your client wants to close at the end of the month, why pick the 31st or the 30th? Why not pick the 24th, the 25th, the 26th? Those are better days. Don't pick the 1st. Pick the 5th, the 4th, the 6th. Way better days. Don't pick the 15th. Pick the 12th, the 18th. Just a few days staggered off the 1st or the end of the month or the middle of the month will make a big difference, because also the lawyers are rushing to close all the deals. So what happens when we rush? We can make a mistake. What's going to be the level of attention and customer service your client's lawyer is going to bring to that client that's buying when they got 12 other deals closing that day? Not as good. So your customer's experience will not be as good as well. So think about that for them too, and offer them a better experience. It'll be smoother, less likely to have delays, right? Like when we're trying to close 10 deals in a day and we're struggling to get them all done, well then some deals get pushed to the end of the day. And if there's some problems with it, then it's probably going to get pushed to the day after, and then your client's not going to be happy. You're not going to get paid as early. So just think about that as well. It's better for everybody. Friday closings, not ideal. Because what if the deal doesn't close? Most deals do close, as we know, but not every deal closes. So if it doesn't close on a Friday, well then what happens? It closes maybe on the Monday or maybe after. But at a minimum, it's not closing on Saturday. We all know that. So then your clients now may be a little bit ticked off that now if they wanted to move into the property, they're not moving there on Saturday. The earliest they're moving in is Sunday, so that's 3 days later. So a better day of the week is like a Tuesday or a Wednesday as opposed to a Friday. Okay, selling, buying on the same day. I see that too. I understand why, because the seller / buyer wants to sell, get the proceeds, and buy the same day. You don't have to do that, right? There's bridge financing. It's readily available. It's easy for buyers to get, and it's not expensive. So you can make the purchase happen, let's say a week or 10 days before. Tell your client to go get bridge financing. It'll cost them maybe $300 to get bridge financing for a week to 10 days. Then they can buy before. And what if there's a delay in the purchase? Now you've got a nice buffer of 10 days or 7 days between when they're then selling the next property, right? So they can also take their time to move into the property they're buying. Because now they're not rushing to say, no, I have to be out today, I have to close today. And who are they calling when they're panicked and they're pissed off on the closing day if it doesn't close? Not only the lawyers, but they're probably gonna call you guys, right? So it's like your relationship with your client will be maybe impacted negatively to an extent. They might not hold you completely responsible, but it's not gonna be as a positive of an experience. So take advantage of bridge financing, remind your clients. Your clients will thank you. Okay, deposits. So generally speaking, if a deal doesn't close because a buyer fails to close, and it's the buyer's fault, the deposit is generally going to be forfeited to the seller. The seller took the property off the market and was negotiating and dealing exclusively with the buyer. So the courts will generally compensate the seller with at a minimum the deposit. That doesn't mean that's the end of it though. When the seller takes the property off the market and deals exclusively with one buyer, now they've said no to any other interested buyer. So if the buyer doesn't close, now what do they have to do? Well, they're going to have to put it back on the market. They're going to put it back on the market, and who knows how long it's going to sit on the market, and who knows what price they're going to get for the property. So if they have a deal locked in with a buyer to sell it to the buyer for $100,000, and the buyer doesn't close, they put it back on the market, and it happens 3 months later, and they sell it to someone else for $80,000, the buyer's responsible for $20,000 of the difference, minus the deposit that's going to be forfeited to the seller. That's not all the damages to the seller. There's also increased legal costs. There's also maybe mortgage costs. They're going to have to pay their mortgage for another 3 months. Utility costs, etc. All those costs are recoverable against the buyer. Right? So just to give you that background about what happens. The seller, what if the seller fails to close? It's the same concept. If the seller fails to close, the deposit should go back to the buyer. Now, we know that doesn't always happen all the time because sometimes you have parties that are stubborn and they don't want to sign the mutual release if the brokerage has it, so that now you're stuck maybe having to go to court. But assuming that the seller and the buyer agree and the deposit is forfeited to the buyer, still there is damages that the buyer could incur as well. Maybe the buyer incurred costs to do an inspection, legal fees, other costs, maybe evaluate the property, etc. Maybe they had to stay somewhere else. They sold their property, they tried to move into this one, didn't close, they're not moving in, they got to stay at an Airbnb for 2 months. They can sue the seller for all that. Those are damages recoverable. Yeah, and if there's a dispute and they don't agree to release the deposit to one of the parties, then you're going to court. So if you're going to court, that's going to take months or maybe years. Not ideal. Always better to try to work it out and let cooler heads prevail, hopefully. Obviously, if you're acting for the buyer, you want to put down the smallest deposit reasonable. And I use the word reasonable, like not, obviously no one would say $100, but something reasonable so that way if it doesn't close, your buyer's not forfeiting a massive deposit. As the seller's agent, the listing agent, of course you want to see the largest deposit, right? So, I think you guys already know that anyways. Okay, as is, where is clauses. So what is an as is, where is clause? It's a clause where basically the buyer is going to acknowledge that they're accepting the property in the condition that it's found, the physical condition that it's found, and they can't complain against the seller afterwards if there's a problem, right? So the seller's not giving any guarantees, no warranties about the actual physical condition of the property. So it's kind of buyer beware. Now, you guys know this better than I do, but if you're going to put an as is, where is clause, you guys can tell me if I'm wrong, but I would imagine you're probably going to get maybe people that are not going to offer as much. Do you guys see that?
Yeah.
Right. So you don't want to put it in there unless there's a valid reason, because then now your seller client's not getting as much of a return, right? So, but there's some situations where you do want to do it, where you want to actually be thinking about your client, protecting your client, and that would be, so if you're acting for a mortgage lender, which that doesn't happen all the time. That happens pretty rarely. But if you're acting for a mortgage lender, the mortgage lender didn't live there, right? So the mortgage lender is going what's called power of sale. The mortgage lender is not intimately acquainted with, is there mold in the basement? Was there a leak in the roof? They have no idea, right? So that's where you should be using it to protect your seller client. If you're acting for an executor of an estate, you want to use it there too. The executor of the estate may be selling the house for an uncle, an aunt, a parent, or whatever. Then they're not going to be intimately acquainted with the property. Protect your seller client. Put in the as is, where is clause. Power of attorney is another one. Power of attorney also is not going to be intimately acquainted with the property. That's where you should put the as is, where is clause in. Trustee in bankruptcy. I'm sure you guys probably have not dealt with those very much. I haven't seen a lot of them. But if ever you were dealing with a trustee in bankruptcy selling someone's property, that's where you should also use it too, because a trustee is also not familiar with the property. Are they bulletproof? No, they're certainly not bulletproof. They're not going to protect your seller client in every single situation. Your seller client will still have liability even if there's an as-is, whereas clause, if the seller made fraudulent misrepresentations to the buyer. If the seller concealed defects about the property, especially if they're dangerous defects, like, oh, I know that the floor is going to collapse, and I'm not going to tell them, and then something happens. You can't stand behind an as-is, whereas clause and be protected. Now the courts, in a situation where it goes to court and there's litigation because the buyer found a defect and is suing the seller, and the seller's defense is there's an as-is, whereas clause, the courts are more likely to hold them up in a commercial context. If it's a commercial transaction, the court will be more amenable to upholding it versus a residential situation where they're not going to be as likely, I'm not saying they won't hold it up, not going to be as likely relative to a commercial transaction to holding up the as-is, whereas clause. They're more sympathetic to the average Joe getting screwed over maybe if a seller didn't if the seller didn't disclose something that was important and the seller's trying to hide behind the as-is, whereas clause. If you're acting for a seller, it's better for the buyer to do an inspection if you want to put an as-is clause in. The reason why it's better is because that way if something goes wrong and they did an inspection, your seller client is more protected because the buyer did an inspection. So if the buyer complains later, well, you've got the as-is clause to protect your seller client, and then you've also got, well, Mrs. Buyer, you did an inspection, so you kind of knew about the property, and there's an as-is, whereas clause. All very difficult for the buyer to sue the seller in that situation. The most bulletproof way is to disclose any issues, right? And of course, not all clients are going to tell us everything. But if your client knows of any issues with the property, the best way they can protect themselves is to disclose. And the way to disclose is not oral, it's in writing, email, or other way you can put it in writing. This is an excerpt of a precedent clause that I use for as-is, whereas clauses that I've sent to other realtors before. I'm happy to send it to you guys afterwards if you want. This is only an excerpt of it because you can see at the end I put etc. But what I like about this clause is, number one, in the first sentence, it talks about how the buyer is acknowledging that they have inspected the property, which is what I was talking about before. You want them to inspect the property, if you're going to put the clause in, and this is where the buyer is acknowledging that they did inspect it. Now, if the buyer doesn't inspect, then you say, well, then what do I do with that? Just change it, and then you can say, the buyer is hereby waived their right for an inspection. That's how you can change the first sentence. Then the second part of the sentence, we're talking about how it's subject to the provisions of paragraph 10. That's the underlined part towards the end of the clause. That's critical for a buyer client. Critical, because you don't want, if there's going to be a title issue that's going to arise, if there's a work order issue that arises, and you're making it subject to paragraph 10. Paragraph 10 is the paragraph in the Standard REA APS talks about title. So if you have a title issue and you don't have that in there, it's conceivable a seller and the seller's lawyer could say, sorry, we don't have to fix any title issues, we don't have to address any work orders, we're selling as is where it is. And then you and your buyer client are going to say, that doesn't make sense. It's as is where it is regarding the physical condition of the property. We didn't say that we're actually going to be accepting all legal issues. But there's an argument to be made. So why give the seller and the seller's lawyer a leg to stand on and make that argument and make life more difficult for your buyer client? Put the one line in. It's not that much more work to put it in. Next slide, please. Title insurance. I'm sure you guys are generally familiar with title insurance. So let me talk about title insurance for a second, what it is. So title insurance covers a buyer or a lender, not just a buyer, but a lender too. So the mortgage lenders make it a requirement. If I'm going to give you a loan, you're getting me a title insurance policy. This is the lender now talking as if I was the lender talking to a buyer. You have to get the mortgage lender a title insurance policy. You've got to pay for it for the lender. So it's to cover lenders and buyers of any title-related issues that could arise in the future that have a negative impact on their title. or even the value of their property. It also covers their legal fees as well. So what does it cover? So it covers unregistered liens, something we don't see a lot of, but you could conceivably have a situation where someone has a lien against a property but it's unregistered. Someone has a right-of-way against a property but it's unregistered. Those would be covered. Work orders. That's the nice thing about title insurance too, which helps us as lawyers and you guys as realtors close the deals smoother, easier, faster, with less hiccups. We don't have to do work order searches. I used to do work order searches for years, and it's a pain in the neck to do them, because then it's more complications to deal with the seller's lawyer when you flag a work order in the city, and you send it to the seller's lawyer, you got to address it with that. Now we've decided not to do it anymore, and we rely on title insurance, meaning the buyers are protected with title insurance. If they discover a work order, then if it wasn't something that they caused, so if they decide to go get a permit to build a deck in the back, and they don't get the final inspection done, they will still be responsible for that. But I'm talking about if they go to sell their property in the future, and the buyer's lawyer, when they're selling, does a work order search and then sticks it on the seller and says, hey, you got to fix the work order. If the seller didn't take out that building permit, title insurance steps up, covers it, so you don't have to worry about it. So it's a very important thing in that regard. Other things it covers, encroachments. Not seen often, but it happens. If, let's say, your client buys a property, we don't do a survey when we're buying. They do that in Quebec. We don't do that in Ontario and all the other English provinces. We get title insurance. But if you got a survey, sometimes it'll show you that there's structures on your land, say your house or your shed, that could be on the neighbor's land, or vice versa. The neighbor could have a structure or a house on your property. That's covered by title insurance. Fraud. Whenever I tell my clients about the fraud, they always get really scared. They're like, I want the title insurance. Give me the damn title insurance. Because fraud is where someone impersonates the owner of a property and goes to see a lawyer, has fake ID, and says, yeah, I'm Jim, and this is my wife, Sally, and we're the owners of 1234 Main Street. And then they dupe the lawyer, and they sell the property, and they take off with the sale proceeds. Thank you very much, and they're in Mexico, and you never know who they are, and it's gone. And then the real owners, if you can just imagine the scenario, it's funny, but it's not funny if you're in it. The real owners are sitting there on a Friday night watching Netflix, and someone knocks on their door. Hey, what are you doing to my property? I just bought this property. I said, what the hell are you doing to my property? I own the property. I call the police, get the hell out of here. And someone bought their property, and they're totally unaware of it. So if that happens, which I've yet to see it happens more in Toronto and Ottawa, they're covered with title insurance. The title insurance will cover up all their losses. Zoning, setback issues, also covered by title insurance. Setback is like where the house is on the property compared to the boundary lines. It has to be set back from the rear, side, and front lot lines of the property. Otherwise, you have to get a minor variance from the city. There's legal fees and costs with that. Errors with surveys, legal descriptions, and land registration documents as well are covered. I'm going to take questions at the end, actually. Okay. What's nice too about title insurance is the cost. It's a one-time payment. You don't have to pay for it every year if you're the owner of the property. You own it for 30 years, you don't pay for 30 years, you pay once at the beginning. Home insurance, car insurance, probably all types of insurance, life insurance. You pay for it the entire time you have it. Title insurance, you don't. You just pay for it once, which is nice. I already touched on it, helps close deals faster, and also gives peace of mind for the buyers and the lenders too. Foreign buyer ban. I believe this is my last topic. So, foreign buyer ban. You guys are, I'm sure, probably aware this has now been with us now for 2.5 years. They extended it, as you guys probably know. It's been extended to January 1st, 2027. It was only supposed to be with us for 2 years. Now it's going to be with us for 4 years unless they extend it again. It's not the same thing as NRST, non-resident speculation tax. Non-resident speculation tax applies if you're not a citizen, you're not a permanent resident, and you're buying in Ontario. Then the government of Ontario charges you a tax of 25% on top of your purchase price. That's separate from the foreign buyer ban, though. Okay, so who does it apply to? It applies to if you're not a citizen, you're not a permanent resident. If you're not a registered Indian under the Indian Act, and you're a foreign corporation. So if you're not a citizen, a permanent resident, not an Indian, or you're not a domestic corporation, then you're considered a non-Canadian, as it's called under the Act, and you can't buy real estate within some parameters. It's not all real estate and it's not everywhere. It's only some real estate, and it's the real estate here. So you can't buy a single-family house, you can't buy a semi-detached dwelling, you can't buy a townhouse, you can't buy a condo, you can't buy multifamily up to 3 units. And it doesn't apply everywhere, and I'll talk about where it applies a little bit later. There's exemptions for who it doesn't apply to. It doesn't apply to if you have a student visa. It's very complicated for a student visa to be exempt, for someone with a student visa to be exempt, because you have to have resided in Canada for 5 years. Possible, but unlikely. Work permit, I see that one a lot. If you got a work permit with at least 183 days of validity, okay? It's not just having a work permit. I just did a deal for some clients this morning. They have over 183 days of eligibility on the work permit, so they're good, they can buy. If you're a refugee, you can also buy. If you're a non-Canadian, but your spouse is a citizen, permanent resident, and you're buying with your spouse, you can buy. That's okay. If you're buying because the purchase results from death, divorce, a gift, or separation, you're allowed to buy as well, even if you're a non-Canadian. Oddly enough, I'm not sure why the legislature decided to put that in there, but they did. Maybe they wanted to help banks because banks rule the world, but that's another discussion. If the bank is selling the property and the buyer is buying from the bank because the bank's exercising a power of sale, the buyer can buy even if they're non-Canadian. That one's a little bit beyond me. But anyways, it's good for the banks, I suppose, because it casts the widest net possible for who the possible buyers are. You know, the banks need a little bit more money. We need to make sure they have every possibility to make more. So that's why. Okay, so you can't buy in areas that are a census agglomeration or census metropolitan area. It's basically the areas on the screen for our local area here. It's Cornwall, Brockville, Kingston, Hawkesbury, Ottawa, etc. You can't buy in those areas. If you want to buy outside those areas and you're a non-Canadian, you can buy. If you're not sure if your client can buy in a certain area, the best thing to do is you can just check the CMHC website. They have a really great tool on there, and you can just put in the property address, and it'll tell you if it falls into a census. Will you go back, please? If it falls into a census metropolitan or a census agglomeration area. The other thing I want to say about this too is that, you know, realtors will send clients to me before they even deal with them. If you're not sure, don't go out on a limb and give legal advice to a client about whether or not they can qualify, because that's going to come back and bite you in the rear end if you're giving advice. As you guys know, according to your code of ethics, you're supposed to refer out if it's outside your area of practice and expertise. So if you're not sure, send them to a lawyer to get the advice as to whether or not they can actually buy. Okay, what are the consequences? So the consequences to the non-Canadian buyer are severe, but I'm not talking to non-Canadian buyers, I'm talking to you guys as real estate agents. So if you guys help someone who's a non-Canadian or don't pay attention to it, and you help them buy a property, then you personally could be liable also for a fine. So could a lawyer, so could a mortgage broker. The fine is up to $10,000. The court will also order the sale of the property. The most amount of money that the non-Canadian buyer will get back is the amount they put in. So if the property doubled in value, you forfeited any increase in equity, you only get back the amount you put into the property. And also there's of course the possibility, I'm not trying to scare you guys, there's a possibility if you were involved with a client who's a non-Canadian, they buy, they're obviously not going to be happy, and they're going to lose maybe a lot of money, they're probably going to be looking to sue. So who would they sue? They might sue the lawyer, they might sue the real estate agent. So obviously just make sure you protect yourself and get them to get legal advice. That's it.